is Rachael Griffith. I'm a family law lawyer in Tyler, Texas, and I manage the Griffith Law Office. We have an office in downtown Tyler. I'd love for you to come chat with us. Today, I want to talk to you about mediation, what to expect. Mediation is usually required in all family law cases before you're allowed to have a final hearing. Most of the counties in East Texas have local standing orders that will let you know whether or not the judges require it before you have a final hearing, and most of them do. And so what to expect from the mediation day. So typically, your attorney's office will schedule with the mediator ahead of time, and you will know when the mediation is supposed to occur, where it is it in person, is it virtual, how long will it last. Most mediations are either scheduled on a half-day time frame, starting around 8:30, going to 12:30, and then, or in the afternoon, maybe 1:30 to 5:30, or it could be scheduled for all day, 8:30 to 5:30. In that case, you need to know what to expect on your lunch hour. You expected to bring something yourself. Most of the mediators in East Texas will provide lunch for you if you're scheduled for an all-day mediation. So that's really just the structure of getting there. When is it scheduled? Where is it? What will the fee be? Most mediators charge a fee per party, a half-day or a full-day fee, and then they will outline in their confirmation letter whether or not there's a cancellation fee if you need to cancel within 24 hours, or if there is an hourly rate if you go beyond the time that you schedule, so that you can know how to budget ahead of time based on the time that you're spending with that mediator. Once you get to mediation, most family law mediations, especially in East Texas, are conducted where you are in one room with your attorney, the other person is in the other room with their attorney, and the mediator will bounce back and forth between the rooms to go over the process, to hear that person's perspective on the issues at hand, and convey settlement offers. Typically, the petitioner, the person who filed the lawsuit first, the first to file, will have the first offer, and that will be who the mediator starts with. And so they can hear about the case, get a settlement offer. If y'all have already started settlement negotiations before mediation, maybe you can tell the mediator what the latest in the settlement discussions were, if you're still on the same page and want to work off of those, or if you have a whole new offer to send over. The mediator will get confirmation from you on what they're authorized to bring into the other room for their settlement offer, explain it to that other party, and then come back to you with a counteroffer. And that's how it'll work, back and forth, until ideally you have resolved all of your issues. Now, everything in a mediation is confidential. So the mediator cannot be called to testify later on about what happened at mediation. If you do or don't settle, you can't get the records of the mediator. They do that to promote open discussions in mediation so that you won't be held against you at trial because you offered XYZ at mediation. You don't settle, and you can say whatever you want as far as your position statement at the final hearing in front of the judge. You don't have to only present to the judge what you presented at mediation. All of that's confidential. So the mediator goes back and forth and tries to come up with a settlement. There are a few different ways that the mediation could wrap up. One, you have a full settlement. You put all of the agreements into a document called the mediated settlement agreement. The mediated settlement agreement will spell out what the terms of the agreement are, the effective date of the agreement, all the parties involved, and it will say in big, bold, all caps language that this mediated settlement agreement is binding and irrevocable. There are very few circumstances where you can sign a mediated settlement agreement and then break open the agreement and have it not apply. If you sign it, you will be held to it in most cases. So before you sign it, make sure you can live with it. That's one way that a mediation can wrap up, is you have a fully binding mediated settlement agreement. Another way is maybe it's partially binding. Maybe you settle a few issues, what the child support number is going to be, but you haven't decided custody. You just cannot agree on a possession schedule. But you want to go ahead and put in the mediated settlement agreement what the child support is going to be, and so that you have that binding and you don't have to try that issue in front of the judge, or vice versa. Sometimes People in a divorce case with kids will settle the property issues, but they're leaving the kid issues to the judge. So if you do that, you'll have a partial mediated settlement agreement. And you'll sign the irrevocable binding language on the parts that you agree to, leave for the court other issues that will be decided with the judge or a jury. Then sometimes you get to mediation and you realize maybe we're a little premature. We don't have all the information that we need to make an informed settlement. You will recess that mediation, pause it, go get the information that you need, and you'll come back to mediation at another date. And the court will be updated if you need to maybe move a hearing, so that can be done. Common issues that pop up where this happens, sometimes you need an appraisal of a piece of property. You disagree in a big way on what a house is worth. One party thinks it's worth $100,000, the other party thinks it's worth $1 million. You're too far apart to really engage in meaningful negotiations, so maybe we need to get an appraisal done of that property. Sometimes psychological evaluations need to be done. Substance abuse evaluations need to be done. There's other issues that maybe you just need more information before you're able to settle. So you'll recess and come back. And another way, maybe you just cannot resolve your issues. You are at an impasse and there's nothing that you can settle. And so the mediator will make a good faith attempt to try to settle, to see if some things can be settled. You may be there banging your head against the wall for the whole 4 hours that you're scheduled to be there, really making an effort so that you can say you made a good faith attempt at negotiations, but there's just no way that you'll have a meeting of the minds. So the mediator will usually write a letter to the court saying these parties appeared, there was a good faith attempt at settlement, but there was an impasse, and you'll settle your case for a hearing. Those are the most typical ways that mediation can wrap up and close out. Sometimes, every now and then, you will get a mediation that turns into an arbitration. That can only be done if it's agreed by all the parties. So that mediator that was not a decision maker in your case can maybe be a tiebreaker on some issues and say, hey, y'all have agreed that I can arbitrate this now, that I will decide the outcome of some of these contested issues. That's usually only done, it's only done if all of the attorneys and the parties agree that the mediator can now assume that role. I hope this information helped you prepare for your mediation, know what to expect, helped you feel more confident going into your mediation. Of course, schedule a time with your attorney to review your possible outcomes at trial. You may want to talk about what is your best day in court and your worst day in court so that you can narrow the likely outcomes that you can live with at mediation and how it will go. It's really a time for you to have your own hands on the outcome of your case and not leave it up to a stranger in a black robe on the day of trial. Mediation, it's a great tool to use to try to wrap up your case so that you have a say in what will happen with your kids, what will happen with your property, and ultimately all the issues in your case. So please take mediation seriously and talk to your attorney about what to expect.